go forward. So welcome everybody. This is our, for those who are a little bit new to this is a monthly meeting we hold for folks who are involved in post-conviction litigations, whether through a CIU or through an innocence organization or defense counsel. We try to cover topics which are of interest to anybody who's working in this space, and we really encourage folks to participate as much as they can as we go forward. So today is that we're kind of continuing from last month, which is a discussion about live suspect investigations and how different they are from kind of a more traditional post-conviction investigation where either the potential perpetrator is deceased or unavailable or even unknown. These are situations where there is a suspect and the district attorney's office is trying to develop a case against them so that they can be prosecuted under the law. But we know that these raise particular issues that have to be paid attention to. And I'm going to blame Lauren Lipscomb for all this because this is her idea to do a series of discussions on topics which may be unfamiliar to people who are coming into CIUs to run them who may have been defense counsel before, or even those in situations they just haven't addressed it yet. So this is one of those topics that we're covering. We're going to be moving in over the next couple months. We're going to I've been trying to kind of put together the topics for those. Looking toward next month, hopefully we'll have somebody from the Institute for Innovations in Prosecution. Those of you who run CIUs know through the newsletter we sent out that they just recently put together a kind of toolkit for dealing with police misconduct issues, how prosecutors' office should be tracking police misconduct, how to make that available through your office. And I thought that would be of interest to people in CIUs, particularly in smaller jurisdictions. So I've asked the person who put that report together to join us to talk about that and to kind of really try to answer some questions for folks about implementation of that. Going forward, we also want to do, I think in October, a focus on just something that I know none of you have had to deal with, judicial pushback. How do you deal with the situation where prosecutors and defense counsel are coming into court and they are agreeing on a situation, how to best present that to a judge to minimize the possibility that the judge may push back or even deny the petition, even though it's agreed upon. So Sonny Eaton, who is with the Davidson County, which is Nashville, Tennessee CIU, will be part of that discussion, hopefully asking other folks on this call to be a part of that as well. And if you would like to be a part of those discussions, the main discussion, please let me know in the chat and I will absolutely be in contact. And I promise it will be more in advance than the night before, which is how I notified our folks today. So as I said, today is kind of part 2 on the live suspect interrogations. And I'm looking through to see if Craig has joined from Suffolk County, New York. I don't see you here. So we're going to be winging a little bit. So until he comes on, Teresa, we're probably going to move forward to the topics that you were going to cover. But we're going to cover several topics today, which being to how to work with police on these issues, kind of still protecting the relationship of the prosecutor's office and engaging with police to investigate a live suspect while also trying to get information from them about a closed case. And that will be Teresa Hall from Florida. We'll be discussing that. Lauren and Linda are going to be tag teaming, I think, issues about disclosure, how to disclose the information as it's coming in to defense counsel for the applicant to the CIU and how that gets handled in a live suspect investigation and why that may be a little bit different and some of the concerns and difficulties that prosecutors face in those. And Lauren also will be working and talking with us about working with the victims and the special issues that arises when you have a live suspect investigation going on simultaneously with a CIU investigation. And then if we have time, what I'd like to do is kind of it has occurred to me that we have about 50 folks on this call from all over the country. And rather than kind of asking you to come to a meeting where you're just talked at for an hour or so, I'd really like to try to make this more about problem solving for you. So introducing a new segment this month, which would be if you have an issue that you'd like to kind of get some feedback on from people all over the country who are doing this kind of work, please send me a private chat with that question, and then we can hopefully address that in give you some space to ask the question and get some feedback on it before we all leave today. Going forward, I'd like to actually save probably 15 or 20 minutes of these meetings to be able to do that. If you have an issue that you'd like to get feedback from prosecutors and defense lawyers who are very thoughtful and intentional on these issues, send me an email ahead of time and we'll kind of put you in the agenda. But I want to try to work ways to incorporate more of an interaction for folks who are coming to these trainings rather than just kind of sitting there listening and then going about your daily routine. So if you have an issue that you are kind of perplexed about or would like some feedback on that you're facing in your work, even right now, please just put it in the chat to me directly. We'll see if we can be able to get to it toward the end. The chat function is open. We do that intentionally, so please feel free to talk with each other as we go through this. Just be mindful that if it's critical, I don't want to go into everyone. And just finally, I would ask you, if you feel comfortable, to please turn your cameras on so that our speakers are kind of talking to faces and not just blank screens. It is very much appreciated from those who are putting themselves out there. So I'm still looking for Craig. He was trying to dance a little bit. Oh, there he is. Hey, Craig.
Greg's here, but his camera's not working, so I can't follow that instruction.
Okay, well, that's unfortunate, but it's great to have you with us. So I am going to, in just a second, hand this over to Craig McElwee, who's from the Suffolk County Conviction Integrity Unit. Craig's going to talk to us about interviewing the live suspect, or trying to interview the live suspects, or handling that investigation. And I'm sure we'll be open for questions from folks. Very often when these cases come to a CIU, if there's a live suspect, the Innocence Organization or Defense Counsel may already have reached out to that person, either conducted an interview or tried to conduct an interview. So there may already be a record of that interview somewhere where the prosecutors are trying to deal with that. But prosecutors also just have to kind of think through how they approach that person, if they approach that person vis-a-vis an investigation going on all around it. It's quite a complex issue. And Craig, I'm very grateful that you can, that you're with us today to kind of help walk us through that. Where'd you go? There you are. So
Here.
I'm gonna go on mute. I'm gonna highlight Craig's background for the rest of you. And I'm gonna just go on mute and let him take it. Thanks, Craig.
Look at that. I got it working.
Good to see you.
Me too. All right. Hello, everybody. I don't know if we went through who I am. My name's Craig McElwee. I'm in Suffolk County, Long Island. Became chief of this bureau in October of last year. My history is I was a prosecutor in the state of Florida, prosecutor in Suffolk County, New York. In 2004, I left Suffolk County District Attorney's Office and was a defense attorney for about 14 years. Over that period of time, I was trial attorney in 12 homicide trials and a total of 40 jury trials during that short period of time. In 2018, I came back to the District Attorney's Office under Tim Sini, who was elected in 2018 after our sitting district attorney resigned and was subsequently indicted federally. Our police chief had recently been arrested and indicted federally. Our chief of public corruption was indicted federally. They've all since been sentenced. Our district attorney, our former district attorney and chief were sentenced yesterday to 5 years in prison. The police chief about 3 years ago got sentenced to 46 months in prison. Based upon that, Mr. Sini, when he came into office, felt it was very important to kind of review the past history of our office and its prosecutors. We additionally had a prosecutor who resigned after it was found that he had violated his ethical obligations under Brady and Giglio and Rosario by not turning over exculpatory information in one murder trial, where we subsequently found out that there was additional information in the second murder trial, resulting in that 40 and a life sentence and conviction being overturned and not proceeding forward. We're engaged in a project right now reviewing 22 of his prior convictions and have found other issues. That being said, the topic of this, one, we had a pretty high profile exoneration, a gentleman by the name of Keith Bush, who served over 30 years in prison for a offense that occurred in 1974, where he was alleged to have attempted to rape and murder. Well, he did. He was convicted of the murder and attempted rape of a young lady. Subsequent to that, we found in regard to an alternate suspect. Unfortunately, that alternate suspect in that particular case had since died. We couldn't interview him, but apparently he gave a confession, a statement that said that he tripped over the dead girl's body, and the items found on and about the dead girl's body were in fact his, but they must have fallen out of his pockets at the time that he tripped over the dead body, and didn't report it because he didn't want to get in any trouble. That person, about a year later, was convicted of the rape of a 15-year-old girl, and subsequently sentenced a considerable amount of time in jail for a crime that was very similar to this one. More recently, I have a currently open case where there is an alternate suspect who is luckily still alive. He's currently on parole. He is, in those matters, represented by an attorney. We are working in conjunction with a post-conviction innocence clinic at New York Law School. So it gives our office a little bit of an advantage in regard to reaching out, speaking to people, and establishing contact. However, in regard to a live suspect, this individual, obviously, we have to be careful in regard to speak to him. We have to check the statute of limitations, see if he's in any danger. What we had decided prior to doing anything else was that we would reach out to our 18B program, the appointed attorneys, and if necessary, have this individual assigned an attorney for the purpose of interview. Adele Bernhardt, who works with us through the clinic, had contact with us. I actually took upon myself to do the research into who had represented him in the past. We reached out to that attorney who told us that he was not represented in regard to this. We checked into the statute of limitations, found out that he was not in any danger of prosecution. When we attempted to speak to him, the clinic reached out to speak to him in the absence of the CIB and the district attorney's office. And he wanted to go through his attorney. He said he wanted to speak to his attorney first. In any of these situations, we have the issue, obviously, whether the person is in danger of being charged or not. You're always going to have a reluctant individual who's going to choose whether or not to speak to you. So the way that we are able to handle that in our situation, luckily because we have the clinic, is to have somebody outside of our office where they can establish the initial contact with that suspect. Most offices don't have that situation. So our practice outside of that is very simple. Is once it gets to the stage of the investigation, where we feel that we do have a credible outside suspect, we will always attempt to have, we won't go forward unless we can have that person assigned counsel. We have a close working relationship with our 18B administrator. He does not have an issue with that. We have not had an issue with anybody approving funds for that purpose. And again, we are in a unique situation in Suffolk County because we have had such issues with our sitting DA, with our police chief, such where people do go out of their way to be somewhat cooperative with us, whether that is the police, the judges, legal aid, we work in close conjunction with, and the 18B program. Not sure in regard to other jurisdictions, if there's been any specific problems or any specific questions about this that I'd like to, if anybody wants to unmute and ask any specific issue that they'd like addressed, I'd like to be able to address that.
So Craig, don't know if anyone else was going to ask this question, but this is Marissa. You are pretty reliant on the court to be able to appoint counsel for a particular in a suspect situation. I don't know if it's fair to ask you to kind of hypothesize what would happen if you didn't have that, because a lot of courts won't appoint somebody just to do investigations. I can shortly say would not happen in Philadelphia. without a pending charge. So, if you didn't have that pending charge, would you be trying to make some kind of pro bono representation? Do you go to counsel first? Like, how do you think you would handle that?
Well, we actually, again, with the great amount of attention that we've specifically gotten, again, we may have an advantage in that situation where we have had local counsel offer to represent clients in the absence of actually ever being assigned. Our independent review panel, which we have, which I know Brooklyn has, are members of 2 out of the 3 members of our local bar. One is very heavily involved in the appeals. The other one is the current president of our Criminal Bar Association. Suffolk, again, is unique in that we have a Criminal Bar Association that includes judges, prosecutors, and defense attorneys. So the relationship there is a little bit more collegial. But our president, who is also a member of our independent review panel, has offered to seek volunteers for any purpose in regard to the Conviction Integrity Bureau. We have proved ourselves numerous times in regard to our sincerity and our devotion to actually seeking justice, which again is something that's hard to convince defense counsel often that we are actually seeking, since we are a part of the district attorney's office, and they've learned over time not to be completely trusting of our district attorney's office.
And I actually, that was going to be my next question on that, because so much of this does involve trust and does involve the mutuality of that. And you talked before, and Adele has talked before about the relationship that you have with the New York Innocence Clinic. But in terms of dealing with private defense counsel, how do you try to overcome that skepticism? And quite frankly, from your introduction, sounds like it's pretty deserved. What steps have you taken to try to reach out to defense bar and try to say, look, we're not that bad. Trust me, I'm from the government and I'm here to help you. Right.
Right. Well, in establishing our Conviction Integrity Bureau originally, there's very strong recommendations that you seek somebody that's not a career prosecutor. I know that's not an option in certain CIBs and CIUs. However, the DA came to me probably about 8 months into my tenure at the office, and we talked about how my unique background really lent itself to this position. So I was a former president of the Suffolk County Criminal Bar Association. I was a very active member of the Suffolk County Bar. I was I don't like to give myself adjectives, but I was a prominent defense attorney within the community. My relationship within that community when I came over, the reaction was great. Finally, we'll have somebody who understands us involved. And I think that really is, again, for us, I'm sorry to keep saying we're unique in some ways, but for us, that really is something that we have, where I didn't have to earn their trust. I had to convince them that they could trust me to trust everybody else around me. And I think that's what the importance of whoever it is that's leading your conviction integrity unit or bureau, their job is to gain the trust and say, you don't have to trust everybody. You just got to trust me to make sure that I'm going to make sure that everybody lives up to your expectations of me. Again, that's not always easy. And there are certain defense attorneys who are never going to be on board with that. But I mean, that really is the path you have to take, whether that be through when I go through my IRP and I submit something to them. They've caught my prosecutors a couple of times, former prosecutors who are now working, former courtroom prosecutors who they've gone up against, where they put something in a report where they find that it's inaccurate. And there is no fighting against that. You have to concede. You have to say, yes, they did prejudge, they were somewhat biased, or they just made an honest mistake. And if you're honest with them, that's how you build trust. Same thing with the defense bar. If they bring something to your attention that either your office has failed to do or that you have failed to do, and you're caught in a situation where you have to admit you can't, unless it's worthy of fighting against, it's not something you fight against. It's not something you argue. It's something that you gain trust by conceding and going forward with that. You're going to go out and talk to one of their clients, former clients, future clients, about the fact that he may have committed the crime and try to convince them that you're not going to end up prosecuting them, or your office is going to start prosecuting them, that's a whole lot of trust they ask them to have in you.
But in these cases, of course, we're talking about cases where you are trying to prosecute and you are trying to go after that individual. You're not talking about an immunity deal or something else. You're talking about trying to get the actual perpetrator and hold them accountable. So you're kind of putting on your mentor hat. What advice would you give to folks who are starting in a CIU, who may have come from the defense bar for that and are now faced with the situation of, all right, I've got a live suspect here. I want to try to go after them, but I still need to kind of protect his rights. What would be the kind of SOP that you would recommend for those?
But the difficult part of that is, and I know just talking from other people within this group, some people work with their own units within the office to conduct the investigations. For us, we have, specifically in our directives, while we work within the district attorney's office, we act completely separate from all of the other bureaus. We don't cross over. We don't have, we have investigators in our bureau that don't work doing investigations into criminal prosecution. So I wouldn't use my DI to go out and interview that person. However, making a recommendation to somebody outside of here saying that we have an old suspect, here is the situation, handing that off to another bureau is something that, sorry about my lights, that starts and ends with that referral. If we have this information, just like any other evidence collection, whatever we have, we refer that, let's say, to our major offense bureau. We might hand that off to our major offense bureau. They have their investigators look into it. We wouldn't get directly involved in the actual prosecution of that alternate suspect. We would just be involved in the evidence collection in that. Anything they turn up, if it turns out that they then make an arrest, obviously, we would take that information as part of our considerations, but we don't actively involve in the, investigation in regard to any potential arrest.
Okay, right. So I wanted, of course, pause and see and look to see if anybody has a hand raised for a question or additional comment for Craig, or to put something in the chat. If you do, please feel free. And not seeing any. So Craig, thank you very much for that. Much appreciated. I'm going to, Craig, you can take over emceeing now if you want to, or I'll just keep it moving along. So the next topic we thought folks would want to hear about is working with police in that. And I would be very remiss if I didn't point out that at this moment, the Philadelphia District Attorney is holding a press conference that he is bringing contempt charges against the entire Philadelphia Police Department for failing to turn over materials. So Philadelphia may not be the best place for this discussion. So I'm very happy to have Teresa Hall here, who's from Tampa, to talk with us about these issues of working with police kind of side by side, protecting that relationship with the prosecutor's office and engaging police in a live investigation. At the same time, when you're a department or a unit that might be often pointing your finger at the department for its failure. So to talk about that dance, I'm going to hand over to Teresa Hall.
Thank you. As Marissa mentioned, I'm down here in Tampa, Florida. I see a good friend of mine on here, Kelly Botter from Indianapolis, helped them get up and running. But what I do want to comment is in reference to working with the police is the very first thing you've got to do is before you have a case that's going to be exoneration or you're going to have a alternative suspect, once you start the unit or once you get in the position of a CRU, you should be reaching out to your detectives, not on any particular case, but just reaching out to them, asking them if you can meet with them as a group, explain what a CRU is, start that relationship long before you get into the touchy subject of an exoneration or an alternative suspect. When we first started our CRU here in Tampa, I rode out with the rank and file. I met with the homicide detectives of both major police departments here. And there was a lot of groundwork that was laid. And I'm going to tell you, it helped some, but they are still skeptical of CRU. They don't trust us. A CRU, really, you're kind of in the middle. The police don't trust you, your longtime line prosecutors don't trust you, and then the defense bar doesn't trust you. They don't know what you're doing. And part of that's because we're new and we're unknown. Some of our policies are still being evolved. They don't know if we're just regular figureheads or if we're going to come in and say they all do something bad. I think it's probably tougher. It's been tougher with one particular police agency here in Tampa for me and the unit, because we did have 3 police officers that were disciplined and or terminated for some issues where we went back and looked at their cases and ended up overturning 17 convictions because of their actions or lack of actions. And of course, that put a sour taste in their mouth. You know, I'm here plastered all over the television with my boss, and they didn't like that very well. When we had the exoneration of Robert Dubois back in the fall, we did develop an alternative suspect, and we've handled that probably completely opposite of what maybe Suffolk County did. Our prosecutor's offices in Florida, we don't really have investigative powers for a pending prosecution. We are a pending investigation that would lead to prosecution. We don't really, that's not the role we play. The role we play is once somebody's arrested or once the case is ready for prosecution, then we step in and we take on the role. So the very police department that we overturned the conviction for is the one that's supposed to investigate the alternative suspects. And that's alternative, and there is more than one, there's actually 2. And that's been very tough. We have battled a lot because they didn't like the fact that we overturned the conviction. And we didn't come to them before we decided to overturn the conviction, which I don't believe hindsight 2020, I'm glad we didn't, because of the actions that have happened since our CRU investigation that exonerated Mr. Dubois. Those actions that this police department has taken has been tough to deal with, because I think there would have been more pushback for the exoneration. Remember all that confirmation bias stuff we keep learning. They don't, even though this conviction happened in 1983 and nobody that was a part of that investigation is still working for that agency, they took it very personal that we exonerated somebody they thought did it, even though we have conclusive DNA evidence that he didn't do it and that we know who did. And so that's still been difficult. And even throughout the pending investigation now, there have been times that I've been concerned that their actions or the way they're investigating may impact how we prosecute the alternative suspect. But here in Florida, we don't get the alternative suspect a lawyer. We don't, we're not part of that. As soon as he became an alternative suspect, he's alive, he's an alternative suspect. He becomes like any alternative suspect in any investigation. If he wants a lawyer, he can hire one. We read him Miranda, we go through the rights waiver. If he says, I don't want to talk to you, then that's the end of that discussion with that alternative suspect. Now, part of that is because this was a cleaner alternative suspect because of the DNA. It's not like it's all of a sudden somebody said, yeah, I did it, and there's no evidence that he did it. Here it's the opposite. He's saying, well, I don't know who that woman is, and I don't know why my DNA would be there. And he has actually talked with the detectives, but he's never admitted his involvement. So going back to the relationship,
I'm sorry, I just want to interrupt, and I apologize, but you said he spoke to the detectives. Was that part of the initial investigation?
No, that's part of
the or post DNA.
Post DNA. The alternative suspect has been interviewed multiple times by the police department, but we've not done anything like to provide him with a lawyer. If he wants one and we were to prosecute him, then of course we would. If he says, I want one and I don't want to talk to you, then the interview stops. But we don't take on that role to find him legal counsel just because now he's an alternative suspect. We wouldn't do that if there was never a CRU investigation and he was the initial alternative suspect. So we're not doing that. I don't know of anybody in Florida that would take on that role. Now, there's been times that I've gotten pro se petitioners, I've gotten them defense counsel when I thought there was something to their petition, but they're not an alternative suspect. They're somebody that I think may have a good claim, but they're trying to do this pro se and they need help. And I've gotten all kinds of defense attorneys that do this pro bono, and that really has helped build my relationship with the defense bar. So our relationship in Tampa with the defense bar is great. We have it. They were skeptical at first, but now it's great. We still struggle with the rank and file and the detectives with the police department, but I continue to kill them with kindness and go out and ride with them and continue to sell why this is important. And they're always going to be skeptical because they believe once they got the guy, they believe they got the right guy. And you know what? I don't know that I'll ever change that in some minds, but I don't give up. I continue to try, and I continue to try to work with them. And part of that also is getting buy-in from your prosecutors that are actually prosecuting the cases. They need to think that there's a need for the CRU, and they may then help sell it on the sidelines with their detectives. If your fellow prosecutors that are prosecuting people believe the CRU is worthless and shouldn't exist, then it's still going to be hard. So I attacked it from all fronts. I met with every single attorney in this office one-on-one when I first started and explained them, and that was 125 people, explained to them what the CRU does. I then do in-services explaining them what the CRU does. I now have gotten the homicide detectives at this one police agency that I've struggled with. They're doing CLE training on things that don't really have anything to do with the CRU, but they're having to work with me and they're seeing I'm not a defense attorney. So it takes a lot of energy, but I urge you to do it because in the end, you do want to prosecute. Yeah, cookies help. I love that. You do want to prosecute the alternative suspect if you believe that he is the one that did it. Now, I don't know, I don't plan on doing that prosecution if we're able to ever file on that case. I don't plan to do that. That will likely be a major crimes homicide prosecutor that does it, because that to me would be me stepping outside of my CRU role. I will give them all of my information, and of course I will talk to them about what we learned. But as soon as I exonerated Robert Dubois and we knew who the alternative suspect was, I took on a very backseat role in that. And that's probably what I should do if I'm going to keep myself separate from actual prosecutions. But I still keep working with the police officers to sell them on who we are, even if it's one person at a time. But it's for the people that are on here that are CRU people that only come from a defense background. I urge you to set that defense hat off to the side because you're not a defense attorney anymore. And from those individuals that are on here that are defense attorneys or working for an Innocence Project, the CRU will be your friend and might help your client get through the legal hurdles quicker if you can get the judges to, cooperate. And I'm glad we're going to do something on that because we struggled with that here. But I know I was a defense attorney for about as much time as I've been a prosecutor. And I prosecuted homicides. I defended homicides. I've done both sides. And I urge you, if you only have a defense background, or if you're coming at it from a defense perspective, filing a petition with the CRU, you have to advocate for your client. But if you come out swinging too hard, that may turn off the CRU, and you don't want to do that. You want them to be your friend. Now, if you don't trust them, I understand why you might come out swinging. But remember, the CRUs, we're not statutorily mandated by anybody. We're kind of this independent organization that wants to seek justice. And for example, in the exoneration we had with Robert Dubois, that initial memo I got, and I love Susan Friedman, she's with the National Innocence Project, her and I work great together. But that initial memo I got was 120 pages of advocacy, and I had to weed through that to figure out what the issues were. And keep that in mind when you're writing those petitions or when you're submitting something, because there was a lot for me to get through to figure out where we were at.
And we will cover that in the guidelines that we're working on, no doubt. But one thing I wanted to kind of, touch back, and maybe Craig, I probably should have asked this while I had you on the screen. In fact, I'm going to highlight you back. There you go. So is this issue of the live suspect investigations, and obviously we want these investigations to be as collaborative as possible with defense counsel who's representing the applicant. But which means generally, and we'll talk about this in terms of the next discussion with Linda and Lauren about sharing Brady information. But when it comes to, if you're going to be trying to interview the potential suspect, or, if they've already been investigated by police, do you share that with counsel? Do they have the ability to be there for those interviews? If not, why not? And how do you manage those relationships when it comes to that person who is so critical to both of those investigations? Either one can jump in.
I was gonna say, obviously, there's two trains of thought on that. One is that this person is just a suspect, and therefore he's going to be investigated by the police department, and they're going to go in, and you wouldn't necessarily let a defense attorney know in advance that was being investigated. The way that we, I think, again, it's been very limited. Obviously, I've only been here for whatever it is, 9 months now. It's been very limited in regard to when these situations arise. But when we've spoken about that situation, what we have decided is that if we have a credible suspect, and we are the ones that are actually the genesis of the investigation of that person based upon our investigation, in order to maintain our relationship and our credibility with the defense bar, we let them know that, either this person is currently being investigated, you represented them in the past, they're your client, somebody's going to go out and speak to them, obviously that person is going to be Mirandized anyway, said blah, 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 all that kind of stuff. And if that person has half a brain, they're going to actually say, I'm not going to speak to you without my attorney present. I know that happens only half the time. But we just feel it gives us a little bit more credibility with the defense bar when we're the ones that reach out to them and say, listen, he's under investigation, he's going to be spoken to. You may want to be present when the interrogation or questioning starts. But obviously, right, Teresa said, if it's just being handled like any other interrogation, I think it's completely appropriate to handle it that way as well.
And insofar as go ahead, Teresa, sorry.
No, I was just saying, mine was unique. Our alternative suspect was unique in the fact that because the DNA excluded the person that was convicted, we fast-tracked exoneration before we even interviewed the alternative suspect. So Robert Dubois' attorney, Ms. Friedman with the National Innocence Project, she doesn't even know who she doesn't even know who the alternative suspect is, but that's because we already knew we were going to exonerate at that point. Didn't matter what the alternative suspect said because we had DNA. So that was a little bit unique. It wasn't like we talked to somebody that said, hey, I did it. And it wasn't Robert Dubois. It was this guy said, hey, I did it. That would be a little bit different. I would disclose that information once my investigation was complete. I would not, though, because Florida, and we just got a law passed for the CRUs in Florida, a CRU investigation or a criminal investigation is exempt from public records. And quite frankly, if I were to divulge information for an ongoing investigation, somebody would have a cow down here. And so we're not, I wouldn't disclose that. I would after my investigation was done, because I think that's different. I'm done. I think the defense should have whatever they want, because remember, there's no legal avenue to make me do something. It's not like it's a motion before a court. So I would of course divulge it because of Brady. I just wouldn't do it till my investigation was over.
And I think that kind of gets down to, and I think a lot of people on this call, those issues of the public records laws obviously they vary state to state. Many do protect the prosecution's file, many do not. And so it's pretty critical to know in your own jurisdiction what the law is. If you're getting that to a defense counsel, are you waiving that privilege, in either intentionally or unintentionally, and what the ramifications of that are can be pretty serious on a lot of those issues. And actually that reminds me of what the third area that we're going to cover is civil lawsuits that arise after exonerations, and kind of the very interesting and difficult ethics issues they arise. So sorry to hijack your discussion there. Okay, so thanks, Teresa. Thanks, Craig, for jumping in on that. I wanted to once again give folks an opportunity to ask a question before we move a little bit into Brady and discovery issues with Lauren and Linda. But please feel free to raise a hand using the reactions button at the bottom of your screen, or put in the chat if you have a question or wanted some more information about something. I'm kind of on a snooze you lose policy here to keep it moving. So seeing none. Okay, great. Thank you so much, Teresa and Craig. I'm just going to here, and I'm looking at, we're going to shift topics a bit. Lauren Lipscomb's here was going to be talking with us about victims. Right, Lauren? So, although Lauren can, fair to say, pretty much take any of these topics and run with them because she has worked on this so far. And Lauren, apologize, I don't know your current title, but Lauren has recently, this is the curse of the competent. Lauren has, of course, been promoted in her office to more of an oversight position, but prior to that, she was the director of the Conviction Integrity Unit at the Baltimore City State's Attorney's Office in Maryland, and has, as I said, been kind of an advocate for us getting out more information for folks who are new to prosecutors' roles, particularly CIU roles. And so, Lauren, thanks for your leadership on all this. And we've asked Lauren to talk about how prosecutors should be working with victims and handling victims when there's a live suspect, where you're changing your focus of the entire case, obviously from one individual to another, and how you handle that special relationship. And Lauren, if you have time to talk about it, or if you're so inclined to also kind of weld in somehow artfully as only you can, those Brady issues that we've kind of mentioned that in others, and when the Brady issues come up with a live suspect, how do you handle that vis-a-vis the attorney for the applicant who's applied to your CIU? Do you do what Teresa did, which is kind of hold off and then give it all at the end? Is there disclosure in, and how do you handle that? But let's focus on victims first. Thanks, Lauren.
Thank you. I'm so glad to be here. It's so good to see many of you. I feel as though we are all kind of across the country. We have a common goal here in continuing to develop and hone and execute this area of conviction integrity or conviction review in prosecution. As Marissa stated, my name is Lauren Lipscomb. For those of you who don't know me, I have been recently promoted into the position of Deputy State's Attorney for the Baltimore City State's Attorney's Office. And I previously held the position of Chief of the Conviction Integrity Unit. In my new role, I will still oversee the Conviction Integrity Unit. However, I have picked up 5 additional units that I am overseeing within the Baltimore City State's Attorney's Office. And what is a little bit different about our office that other offices tend to do differently is that our office, while we do review cases with an eye toward police misconduct, ferreting out police misconduct, we also review cases with an eye toward sentencing modifications or sentencing parity. However, it's not housed under one roof. So as different jurisdictions talk about the types of cases that they review, in some jurisdictions, I know that the CIU handles kind of just a whole universe of integrity-related cases, whereas in Baltimore City, the Conviction Integrity Unit, which is the new chief, is on the call. She is Linda Ramirez. In Baltimore City, the Conviction Integrity Unit program handles claims of factual innocence specifically. And under my sphere as one of the, as in terms of the other units that I oversee at this time, I also oversee police integrity, the police integrity unit, as well as the sentencing review unit. And so police integrity handles those instances of police misconduct, and then sentencing review unit is the unit that reviews sentences in terms of with an eye toward just and equal sentencing and sentencing parity. Within my role, I could share with you that I actually started in our office almost 20 years ago as a law clerk. And I came through the Baltimore City State's Attorney's Office, progressively working through the district court level, the misdemeanor level, on up to felony jury trials. I have tried many cases, both jury trials as well as I'd say hundreds probably of bench trials over the years. And I've had the pleasure of being the chief of the conviction integrity unit in the past, for the past 5 years. And then I was just promoted into the role that I have now in the last couple of months. With that having been said, I want to just launch right into dealing with or the discussion leading related specifically to victims. As many of you are well aware, and I love that I'm seeing a lot of participation on this call from the Innocence Project as well as the Defense Bar, because I think that this might be a little bit informative to you all as to one of the considerations that is unique of within our house, a prosecution house, or is the issue of when to notify the victim's family. And we are always cognizant in a prosecution office of those victim-related issues. And what I would say is that the overarching theme in the conviction integrity unit is that we don't want victims' families to be notified of an exoneration by way of a press conference. That is really what we are looking to avoid. Now, within that thinking, what I have discovered over the years doing this work is that the main considerations for prosecution offices are checking for your regular victim notification statutes, making sure that you're in compliance with whatever your regulatory scheme is, your local statutory scheme relating to notification of victims' families. Here in Maryland, we have a continuing obligation to notify victims' families, not only obviously pre-trial as we move through the pre-trial process and into trial and sentencing, but also, of course, when it comes to post-trial motions, anything that is going to affect a sentence, we have an obligation statutorily to notify the victim's family. I would also just point out for those who may not know, and certainly for the defense bar, when you're thinking about, why is the prosecutor's office so concerned about, the victim notification issues? In Maryland, we also have our bar licensing requires a certain due diligence of prosecutors with relating to notification of victims' families. I often will mention that there was a prosecutor in a jurisdiction here in Maryland who ran afoul of notifying the victim's family and ultimately ended up being disbarred. There were other matters that were going into that equation. However, one of the factors that was considered was the failure of this prosecutor to loop in and continue to notify the victim's family of ongoing court hearings and trial information. And so that is something that may also apply within your local jurisdiction, is that you may have some licensing, some ethical responsibilities and professional responsibilities related to your bar license as to notifying the victim's family. Again, also, it's probably helpful to develop internal office policies related to this work specifically. And then that way, at least, all of the prosecutors and everyone is on the same page as to what your particular office policy will be with regard to victim notification while doing exoneration, factual innocence claim reviews or sentencing reviews or whatever your conviction integrity unit handles. it's not the worst idea to get some loose policy going or an internal policy that perhaps helps guide that process. And then what I'd like to mention is a major consideration for us here in Baltimore City, and for me personally, is just to remember the human decency of and the psychological and the traumatic sort of angle of victim notifications. These are families who not only have been kind of dragged through the criminal process with regard to pre-trial and during the trial and the sentencing process, not to mention the incident, whatever it might be, the crime itself. This is an extraordinarily, I know that everyone realizes this kind of intellectually, but in terms of just from a sort of decency angle, recognizing that the victims' families are in varying states of trauma related to their contact with the criminal justice system, and making sure that the office as well as any of the staff members keep that in the back of their minds. Also, it's a nice guide as to when you notify. And I know in our office in Baltimore City, we go well beyond what is obligated of us by way of statute or our professional or ethical obligations. We go well beyond that point in notification of our victims. So what I would then like to talk about, let me see if there are any questions so far. Marissa, are there any questions?
Nope, not in the chat. I did have a question though, Lauren, and you may be
Sure.
getting to this, which is kind of, and it goes to that bias issue that we were talking about before.
Mhm.
Obviously, the victim's family has gone through this. They've been told, this is the guy, this is the guy, this is the guy, we've got him. How do you work with them to kind of, or do you, to get them to a different place where you're now saying, okay, oops, we got it wrong. Everything we told you was a mistake. And how do you, or, that dissonance
Mhm.
must be horrible for the victim's family and the victim, or the surviving victim's family, the victims to go through. How do you, is that you doing that? Do you bring in a counselor for that? How do you help them go from A to Q in such a quick succession?
Thanks, Marissa. That's great, because that actually segues right into what I wanted to talk about next. We in Baltimore, we have a victim witness advocate that joins us for the family notification meetings. We like to do the notifications in person. And if anyone has the question of, well, who do you notify? We take the route of going formal. So if it's not the victim themselves, let's say it's a homicide, it's next of kin to the victim, or if the victim's deceased, maybe a rape victim, whoever the next of kin would be is who we start with. And we actually like to bring in the next of kin and any family members who are interested in what we have to say. We like to bring them in and meet with them in person. And during and it is important, I think, for not only the prosecutor who is reviewing the matter, but also a victim witness advocate and or the supervisor of the unit. The reason why I think that is so important is that I think that it sends a good message to the and the victim and or their next of kin, their family, that we take this seriously, that we value how we're handling this case and the trauma that they have been through, that we take it that seriously, that we'd like to have a sit-down meeting, that the prosecutor in charge of the investigation is present, that we have our victim advocate on site in the meeting as well, and the supervisor is present. And we allow a block of time for them to ask as many questions as can come of it. Rest assured, most of them, 75 to 80% of the victims' meetings that we've had have been highly traumatic. We do need to have a box of tissues present when we have the meeting. And in terms of that transition, Marissa, from from we believe this is who did it. We are putting, we're going to trial and we are moving full steam ahead. Transitioning over to we may have gotten it wrong is not an easy task. One of the things that I have realized over the years is that victims' families are, I mean, they're just human beings. The more transparent that you are with the process, the better off you will be. So what we usually present, how I usually present it to victims' families, are that, I start off with things that we can agree on. Like, for example, this incident happened and, as to the people who were there, we are at the mercy of whoever witnessed this, or the DNA, or the fingerprints. Whatever the evidence points to, we are all at the mercy of. And so I kind of try to establish that kind of, I'm thinking back to some of the cases that we've had. We have not had a victim's family member be present at the crime, to be present at the incident. We haven't had, I think there was one case where we had a family member who was present. The rest of the cases, though, the family member wasn't present. And so I like to point out that, again, kindly, nicely, with a very sensitive, in a sensitive tone, I like to point out that they weren't there either, and that we're kind of all in the same boat of sort of heading where the evidence leads us. And, I impress upon them that it is just as crushing for us having prosecuted an individual who we now believe may not have done the crime, that we too are reeling from the circumstances that we have found ourselves in, and that we are sensitive to it. So it's not an easy transition. There's no real magical way to, get the victim's family on board. But what I say, and I think anybody who has sat with me through these notification meetings, and I have been the lead on all of them, would say that usually during the meeting, I say, I'm not here. My role of a prosecutor is to keep you informed of what we're doing, and to keep you informed of the direction that we're heading in and what the potential outcomes might be. As a prosecutor, however, I am not here to tell you what you want to hear. And that's a big distinction. And so I might be delivering news that you might not want to hear, but I'm obligated to still deliver that news, whether or not you want to hear it. And so I'm very straightforward and candid with my responsibility of being a bad news deliverer, but I am obligated to do that. Now, the next sort of from that position, then I think the natural follow-up is, when do we notify the victim's family? And in Baltimore City, we have a tiered review formalized process on how we review the cases. And from the reinvestigation level into the final review, I do a memorandum to the state's attorney and the chief deputy that recommends a release. So if a case is being escalated out of a reinvestigation, that is because it is a recommendation for release. At the same time, right before or about at the same time as doing that recommendation for release, that's when we reach out to the victim's family, because we don't want to reach out too early, because if the case has, if we've just gotten an application and it's just a piece of paper, there's nothing that we're going to do about it. And as Teresa just pointed out, this is not a statutorily obligated unit. We're not in any way obligated to disturb the jury's verdict at all. And so if we are talking about the application, the point of application or soon thereafter, there's really nothing to notify the victim's family of. And so we wait until we are close to a release recommendation or thereabouts. And that is typically 4 to 6 weeks before an exoneration would actually happen in Baltimore City. And so we do that in-person meeting unless they choose not to. We make sure to document this very well. And we like to do it at about that point because we invite follow-up questions, and we've always had follow-up questions. The more time that we allow between notification and when it would actually go into court, the better, because we've heard from, you know, second and third degree family members asking follow-up questions about where we are in the process and what might happen. And I'm pleased to say that it doesn't always go well. I'm not saying that you're going to be absolved, that, you know, after you do an exoneration, you are going to get the calls. I never heard of what was going on. This is news to me. You will have the person standing, you know, with the reporter on the news saying that they were never notified. And to the extent that you have followed your normal protocols related to any other prosecution, you know, talking to the victim or next of kin and documenting that, then you always have, you know, then you at least are secure, maybe not from the perspective of public opinion, but you're at least secure that you have in fact done everything that you were supposed to do ahead of, you know, exonerating, you know, ahead of the exoneration. So that's about the sweet spot.
Yeah, I mean, I was just gonna kind of pushing that a little bit more, Lauren, if you don't mind,
Sure.
because, you know, we have seen situations where it kind of becomes this very acrimonious situation where the victims at one press conference saying they never notified me, I had no knowledge, and then you have the DA over here saying we tried. You know, without, and going back to what you're saying that about how much trauma the victim and their families have already gone through with this, you know, other than kind of treating it like a civil lawsuit where you have to, you know, record everything and depose and sign here and do that. You know, how do you protect yourself against, and I'm just going to use that language, how do you protect yourself against kind of an unfair charge of we were never notified, we had no idea?
So and that's a great question. What I would say is that I would use, because we are fortunate, we are the state, we have many more resources to get in touch with family members. And so I would definitely, and what we do in our office is we employ the investigations unit. We have a full-time investigator within the conviction integrity program. We have him, or we have a unit of investigators as well. We have them go out and, you know, even if it's a backtrack from OCME, the Office of the Chief Medical Examiner, even if it's a backtrack of go to OCME, get the next of kin that's listed on their notification on the autopsy report and in their materials. And we just keep going from there, building out to find someone who is located in the family, and just make sure you document. If there's no documentation, it didn't happen. It's very, very, very critical. And if not at your level, definitely at the elected's level, you will always want to have comprehensive documentation of the steps that were taken to contact the victim's family. Understanding, of course, that a lot of exonerations involve cases that have some real age to them and prove to be very difficult in locating surviving family members. But if you have it well laid out, again, in our jurisdiction, it's when we're starting to have real problems, we go to OCME. And so starting there and kind of working our way out of the medical examiner's office or the coroner's office, I guess, starting from there and then going to whatever investigative resources you have to locate somebody that's in the family. And then whoever you tag in, ask that question, are you next of kin for this victim? If you are not next of kin, please tell us who we should contact, who would be considered next of kin for the family. Or is there a representative of the family? And once you get that representative on the phone, make sure to clarify, sir, I just want to make sure that I'm clear. you are in fact the representative for the family. And I would make a note of all of, of whoever that is. But as Marissa just said, and we've had it happen to us, we've had removed family members so we've had situations where the family is estranged. And we've had where we've met with the next of kin and we've met with the victim's family, but come to find out there's another side of the family who doesn't talk to that side of the family. And that side of the family didn't get news of the exoneration. And so you're not going to be able to, you're most likely not going to be able to cover the full universe of someone's family. And so just going through those, just kind of putting that estate and, the estate's hat on from law school and kind of like going, I know, we don't want to hear about that in criminal law, but putting our estates and trust hats on from law school to determine what the natural legal progression would be in terms of a notification, that will keep you covered and will keep your elected covered when the press comes asking and when the inevitable family member comes asking. And I will say we've also had in our jurisdiction the issue of, we've had a situation where a prosecutor said, oh, I sent a letter. This is a 80 case. It was at least a 30-year-old case. And I sent a letter. This happened. And this was probably about 10, maybe 15 years ago or so. And that letter didn't get to the family. And so, our office went ahead and did, and this was before there was a CIU. It just was a post-trial matter that we were agreeing to relief in. And lo and behold, in the paper, the family read about this agreed relief and just took to the paper. We were not contacted. We've been in Baltimore for the last 5 generations. Anybody should have been able to find some of us because we were here. And so don't ever underestimate. I would always do more, not less. And I certainly would not rely on something as simple as, just sending a letter, making, one phone call. I would use the full weight of the state's office, the prosecution office, to track down the appropriate people.
Great, and I appreciate that. So I've got an eye on the time here. It's about 3:10. We try to promise folks that we will get you out by 3:15. So thank you so much, Lauren and Craig and everybody who's been a part of this. We're very grateful for, and Teresa, of course, sorry about that. Very grateful for your time. So of course, want to open the opportunity for anybody to ask any questions for the folks who have call you panelists, even though we weren't really a panel, about these particular issues. And also, of course, as always, to let me know if there are topics that you want us to cover on future meetings with this. I'm also going to go ahead and launch our poll that we need to track for BJA to make sure that they know that we're actually doing these and that they're going well. So I don't know, Lauren or Linda, if you guys have a moment just to kind of, is there a differentiation between sharing potential Brady material that comes out of a closed case in a non-live investigation versus a live investigation? Like, are there different considerations that you have, not the least of which being that it can get leaked, it can go out, right? And it could impact an ongoing investigation. And how do you kind of address those issues when you are faced with them? I know that one that comes up a lot.
So we follow the ABA model, the guidelines, the rules 3.8. And so what we evaluate is whether the exculpating evidence that we've uncovered rises to the level of clear and convincing. If it does, then we really are obligated to go ahead and share that information. In the case of a live suspect, a parallel live suspect investigation. That information may be in some form redacted. We would talk to the Innocence Project or Defense Counsel to explain why the material is redacted. But in terms of the substance of what we found, kind of like a generality of what we found, if it rises to the level of clear and convincing, we go ahead and turn it over.
Craig, you've unmuted. Are you going to jump into that part of the conversation?
Well, I was actually going to say, I actually have the rule up on my board up here, tacked up to my board, because we have had questions in regard to that, in regard to whether or not certain information in regard to our Kurtzrock investigation, which was the prosecutor that violated Brady in the past, what we had to turn over, what we had to turn over. And that was more to the people who had been previously convicted. And basically are all of them entitled to know that the prosecutor involved in their case was involved in this type of thing. And based upon our reading of that, we believe they are, that they are entitled to certain information, and immediately our obligation as a prosecutor's office, not as the CIB, but as a prosecutor's office, is to turn over that information when it's known to us at our earliest possible convenience. Obviously, there is no danger to the person who has been prosecuted and convicted to now be made aware of the information that's involved. So from that side, not just the ultimate suspect being advised of this Brady information, but to the person who was perhaps wrongfully convicted, turning that over immediately.
Right. And of course, under recent New York law, you have additional responsibilities that you did not have before in terms of timeliness and other issues with Brady investigation for a live investigation versus
Correct.
a closed investigation, which I'm sure will kind of inform how you handle all those. So, okay, I know I jump in and ask a lot of questions, but I have a lot of questions. So I do kind of apologize if I stepped on anybody, but do of course want to offer folks a chance to raise issues now, please. And if not, again, thank you so much, Craig and Lauren and Teresa, for your time. Very grateful for your assistance in this. These are important issues that people are having to deal with every day. And so to have the kind of a framework through which to think of them through, I'm sure is very helpful to folks. So I'm going to keep the room open for a little bit, but I thank everybody for your time, and hopefully we will see you next month. Same bat station, same time, 2 p.m. Eastern on the second Wednesday of the month. So thanks, everybody.
Thank you.